Welcome, everybody. We're pleased to hold this timely session today. The New York Department of Financial Services cybersecurity regulation is final. What you need to know now. My name is Raj Day, and I chair the Global Cybersecurity and Data Privacy practice at Mayer Brown. Cybersecurity Month may be over, but the developments keep coming. So today I'm pleased to introduce three of my colleagues, Justin Herring, Jeff Taft, and Stephen Lilly. Our presentation today will be led by Justin. Justin Herring is a partner in our New York office at Mayer Brown, a partner in the cybersecurity practice, as well as our financial services and regulatory enforcement practice. He joined us earlier this year. From 2019 until this spring, Justin served as the first Executive Deputy Superintendent for the DFS Cybersecurity Division. In that capacity, his division was responsible for all aspects of the cybersecurity regulation, including guidance, regulatory amendments, examinations, and enforcement. While Justin was at DFS, he led the drafting of the amendments we will be discussing today. So naturally, that gives him some unique insights into the regulation, and some of which he's going to be able to share with us. Before he joined DFS, Justin was a federal prosecutor for 9 years in the districts of New Jersey and Maryland, and he served as the first chief of the cyber crimes unit in the District of New Jersey. Justin is going to be joined today by Jeff Taft, who is a partner in our Washington, D.C. office. Jeff is a veteran partner both in our cybersecurity as well as our financial services and regulatory enforcement practices. And he's probably worked with many of you because he advises a range of financial services clients, from banks to mortgage entities to insurance companies. Justin will also be joined by Stephen Lilly, a partner in our Washington office in both our cybersecurity practice and our litigation group. He previously served as chief counsel for a Senate Judiciary Subcommittee and now spends his time assisting clients on a range of cyber matters, from regulatory compliance to incident response. We've got a lot to cover today, so we may not get to your individual questions, but please put them in the Q&A and we will follow up with you individually. So with that introduction, over to Justin Herring. Justin?
Thanks, Raj, and thanks to everyone who's joining us today. I know we have a large crowd here, and we have a lot of ground to cover. As most of you probably already know, DFS's amendment is a pretty significant rewrite. It involved changes to most of the provisions in the existing regulation, as well as the addition of some new requirements. So today we're going to move, we're not necessarily going to hit every single change, and we're certainly not going to be able to tease out all the potential implications, but we wanted to get you started in understanding what these changes mean by hitting some of the highlights across all the different areas that the amendment affects. A couple of things I should note. Number one, it is reasonable to expect that on some of these issues, the department's likely to put out guidance, especially over the next 6 to 12 months. When the original regulation, cybersecurity regulation, was issued in 2017, for more than a year afterwards, the department put out a steady stream of statements and sometimes FAQs that were published online, answering interpretive questions about the amendment. About the original cybersecurity regulation. So it's certainly reasonable to think that the department might likewise make more statements in the coming months or put out more FAQs addressing some of the interpretive questions and challenges that companies are likely to face. That said, there's no guarantee that such guidance or statements are going to be forthcoming. And even if they do come, there are some issues which most companies should probably start working on right now. As we're going to get into in a little bit, some of these requirements will be live as soon as December, as soon as next month. So there's a lot to jump into. Let me go ahead and share our presentation. I'm going to jump ahead here to the agenda. And like Raj said, we really welcome questions from all of you. If you do have any questions, please, you can put them into the chat in this webinar. It should be a private chat so that the other viewers won't see it. And please include your email address so we can respond and get back to you on your question. Or you're welcome to email me directly or any of the panelists today. So today we're going to divide up the changes in the cybersecurity regulation into a few different buckets. We're going to start with incident response, governance and policy, move through some of those other areas, and then finally talk a little bit about the implementation timeline. The different provisions covered by the amendment phase in over the next 2 years, starting in less than 4 weeks on December 1st and running all the way through to November of 2025. So that timeline, in many respects, will dictate what you have to work on and when you have to work on it if you're focused on getting into compliance with this regulation. So I am guessing if you are here today, you already know what the DFS cyber regulation is, but just to level set, since I know we have probably a wide range of past familiarity, DFS cyber regulation, when it was issued in 2017, was the first of its kind for a financial services industry, and it did require, as a regulatory mandate, a risk-based cybersecurity program that addressed a number of different core areas, everything from access controls to incident response planning, required documented in policies and procedures, and it applied to all DFS regulated companies, everything from insurance companies to money services businesses to banks. The rule, since it was promulgated, that regulation has become a model, aspects of the regulation have become a model for many of the other cybersecurity regulations that have grown up over the last year or two, and in some cases are still pending, including the NEIC model rule. On the insurance side, the FTC safeguard rule, and just this year, the CSBS non-bank model cybersecurity rule. So the background for the amendment, the department first stated that it was likely to start working on an amendment and that it was thinking about amending the regulation almost 2 years ago. There have been effectively three drafts published, 2 rounds of formal notice and comment in November of last year and June of this year, and a pre-proposal draft that was published and for which the department solicited comment in July of 2022. The final amendment came out last week, 5 days ago on Wednesday. And as I said, my expectation is that the department will continue to issue sort of guidance, clarifications, and facts in the coming 6 months, facts, FAQs. And the department has also stated that they're going to be hosting webinar training sessions, 3 of them over the next month or so. They've also indicated that to some extent, those will be focused on the small business segment. There'll be sort of outreach to small businesses, of which there are tens of thousands that are covered by this regulation. That said, the content won't necessarily be exclusively applicable to small businesses. We'll certainly be staying tuned for that, and we will continue to provide updates to you and to our clients if there's any meaningful interpretive statements made during those training sessions over the next month. So I mentioned before that there are a handful of requirements that are going to be live on December 1st. So we're starting with incident response and incident notification requirements, in part because those are the requirements, those are going to be the very first requirements to be live, to be effective in the regulation. And I'm going to turn it over to my colleague Stephen in a second to talk about what that means for companies as far as their preparation. But first, just to summarize some of the key changes. The changes that will be effective on December 1st are the changes for incident notification requirements, right? And that is primarily about ransomware. There is a rule that requires notification if ransomware is deployed within the company's information systems. And in addition, there's a rule that requires notice within 1 day if a covered company makes a ransomware payment, an extortion payment, and then within 30 days of that payment to provide the department with a written explanation about the payment, stating why the payment was made, what alternatives were considered, and what due diligence was done before the payment was made, including OFAC due diligence. Those requirements are new, particularly the ransomware ones. Some of them track, one of them at least, the one that requires notification of any extortion payment that a company makes, is actually also in CERCIA, if you know what that is, the federal statute that was passed that authorizes DHS CISA to create a broad federal notification, has in it similar authority to require notice of ransomware payments. So that I expect will come sometime in 2024. But in the meantime, this requirement is the first of its type that I'm aware of that requires notification if you have to make an extortion payment. Finally, there's a notification requirement for third-party incidences. The department clarified in the final version, there was an ambiguity about this in the last draft, but the final version of the regulation states that third-party notice is required when the company would otherwise have to provide notice. In other words, it's not a requirement that you would make notifications anytime any of your third party suffers an incident, only if that incident otherwise, triggers some obligations for the covered company. Like for instance, if you have to make state data breach disclosures because a vendor lost your customer data, that would be a third party notification that's required now under this new rule. And finally, for incident response, the incident response planning requirements, there were several added. There's already an incident response planning requirement in the cyber reg. There's a few new requirements added. Part of them have to do with a requirement for post-incident root cause analysis, and then updates to the incident response plan based on that analysis. There's also a requirement that the incident response plan include planning to recover from backups, and that it be tested at least annually with senior officers. The last draft of the regulation said annual testing with the CEO and senior officers. This version just says annual testing with senior officers. So that requirement was made slightly more flexible in the final regulation. All right, so having gone through an overview of what the new rules are, let me turn it over to Stephen to talk about how you can prepare for these new requirements.
Yeah, thanks very much, Justin. It was a great summary of the changes in this aspect of the rule. I think for many companies, these won't be actually very particularly significant changes, in the sense that many of these incidents would have been reported anyway under the existing rules. That said, I think practically speaking, there probably will be some revisiting by companies of sort of the standards they use to determine whether something has to be reported, and probably overall we'll see a little bit of an uptick in the number of incidents that lead to notifications to DFS. So for example, there is now a per se trigger, for certain types of notifications. But I think that those types of notifications, as I mentioned, probably would be, made anyway. I think the most obvious change that's going to be required is to make appropriate changes to your response plans, so that you can ensure compliance with these new requirements. But one thing I did want to particularly highlight is around third-party incident notification requirements. So I imagine that everybody on the call has had the experience at this point of a third-party incident. One of the real challenges in a third-party incident oftentimes is that you don't have control over the investigation, so you may not be able to answer basic questions. Oftentimes we've seen that third-party incidents aren't fully accounted for in existing incident response plans. And then, one of the challenges about third-party incidents as well is that oftentimes they're a third party that's broadly used within the industry. So if you're affected, it probably means that other peer companies are affected, and that they may be making notifications to DFS. So the third-party incident notification requirement is one that is definitely worth paying attention to and thinking about how you will operationalize that. Might be worth something considering doing a tabletop around if you haven't already. I think that would be a really good, definitely it has some complexity that's worth thinking through in the context of your own business. And then the only other piece I just would highlight now is the summary of the extortion payments that Justin was describing. This is as Justin was saying, like there are other legal requirements going into effect, which will require the reporting of ransom payments over time. But what's interesting about this is it does have the summary of why payment was necessary, the requirement of payment, why payment was necessary, which obviously you'll have to be very carefully written to avoid casting your security in an unduly negative light, or giving folks the wrong impression about the state of your systems. And it may actually be something, frankly, that discourages some folks from making payments, knowing that they would have to think about that. But that's another piece that I think, as you think about preparing for these types of notification obligations, that would be worth thinking about including in a tabletop exercise. So those are just some immediate thoughts that come to mind in this context. So back to you, Justin.
All right, thanks, Stephen. Appreciate that. And I think, one thing I would add to that, and this is really to echo the point that Stephen made, is that it was probably already the case that you could say that it was extraordinarily difficult to get the legal pieces right, much less the actual substantive incident response pieces, if you don't have a plan and that you've tested. And I think that these kinds of requirements really highlight that, right? It's going to be very difficult to take into account of not just the incident notification requirements, but things like having to later submit a written explanation of why you may have made an extortion payment, unless you have some kind of structure and some kind of planning in place beforehand to help you account for that as you're making your decisions and as you're dealing with the incident. So another new requirement in the regulation is the business continuity and disaster recovery planning. One important caveat that appeared through the amendment, through the revision process and the different proposals, the BCDR requirement in the cybersecurity regulation applies to business continuity and recovery with respect to cyber incidents, not more broadly, including non-cyber kinds of business recovery. That wasn't true in the first time this language appeared in the draft, and it was added, but that limitation was added later. The amendment, the requirement for business continuity and disaster recovery, right? I think as with some of the other provisions in this regulation, the degree to which this is going to be new, the degree to which this is going to be difficult to comply with may depend on whether or not you're already subject to a requirement like this, right? For instance, if you are at an institution that's an FFIC regulated bank, some of these elements in terms of having a business continuity and disaster recovery plan are going to look familiar. If you don't, then this may be the first time that you are grappling with a requirement like this. And it does require, it has a number of different elements that you have to account for, including effectively an asset and personnel inventory, where you have to understand what's essential to business continuity and recovery. And you have to have account for everything from documents, data, facilities, infrastructure, and services. And you have to identify supervisory personnel for each aspect of the plan. Plan should include a communications plan. There's also, again, an emphasis on backups, right? The regulation requires the maintenance of offsite backups that are necessary, whatever's necessary to restore critical operations, and that the backups be adequately protected from alteration or destruction, which is a common challenge in ransomware cases, where you have attackers that are deliberately trying to disable your backups. And then finally, again, the emphasis on testing, requirement that the BCDR plan be tested at least annually with senior officers. All right, one of the most extensive new additions in the amendment have to do with the different kinds of governance requirements that we've seen in it. There are governance requirements for boards, for senior executives, for CISOs, as well as expansions of the certification requirement. So to discuss these requirements and what they mean for you, I'm going to turn this over to Jeff.
Thanks, Justin. Appreciate it. The first thing I would say about the board requirement before I talk about CISOs and then the annual certification is we use the terminology board, obviously. The reg really applies to the senior governing body. Obviously, we recognize that there are a number of organizations, covered entities that don't have quote unquote boards of directors. So if you're a branch or an agency of a foreign bank, obviously you may not have a quote unquote board of directors, but it applies to that senior governing body at the enterprise level there. So I think that's something to keep in mind, obviously. What it does is it requires, what the rule does now is it requires that the senior governing body of the board exercise effective supervision over the company's cybersecurity and risk management, and that they have a sufficient understanding of the matters related to cybersecurity and have some oversight of that. Again, the board's role or the senior governing body's role is obviously an oversight role. Management handles the kind of the day-to-day implementation, and they oversee what management is doing. But obviously it's an important role that they perform. And I think you're seeing more and more the regulators looking to hold the boards and senior level people accountable. This kind of a, from the top down kind of approach to compliance, top of the house approach. Obviously they want it to flow down from the board to management and from management down to the kind of the rank and file employees. So I think it's important that people understand that. I don't think this is unusual. Obviously for those of you who are banks, or even insurance companies. I think the FFIEC guidance for banks and the NIC model cyber law contains, consistent requirements for boards or for governing bodies. So this isn't really a new requirement, but it's obviously something that has to be focused on. There was some, question in the last proposal indicated that the board had to have sufficient expertise and knowledge to exercise effective oversight. That requirement was kind of toned down a little bit to have sufficient understanding of cybersecurity related matters, recognizing that not every board or governing body is going to have that detailed knowledge of cybersecurity, which at times can be very technical. So that's important. And I think also on the slide on the right-hand side, you see that there also was in the proposal a requirement that that the board approve the cybersecurity policies. That is something that I don't think that a lot of enterprises were doing. That would have been a dramatic change. That requirement was dropped from the final rule. So now that senior management effectively can approve cybersecurity policies. I think that's historically how folks had handled that issue. So I don't think that's a change at all. And I think that's a good change that the board wasn't required to have that. So let me just move on to the CISO role now. Obviously, they define the role of a CISO, qualified individual, has adequate authority to implement the cybersecurity program. CISO also has to make timely reports to the board. I think those timely reports have to be on an annual basis, but really at this point in the stage of cybersecurity, I think you're getting much more frequent reporting to the board. I think the board wants to hear from it. I think everybody expects to find out when things happen, not on an annual basis where they get a laundry list of all the things that happened that weren't trickled up to the board. So I think that's kind of an important thing. They also clarified in the final rule that it's up to the board to oversee that senior management has allocated adequate resources with respect to the CISO and be able to perform his job and implement an effective cybersecurity program. The proposal kind of indicated that the CISO needed to have adequate resources, but obviously the CISO doesn't allocate himself any sort of budget or resources. So it's really up to board and senior management to make sure that that happens. The final governance point, and I think this is an important one for a lot of people, is the annual certification process. I think there are two big changes there. The first is that the certification will now be signed by the highest ranking executive in the CISO. That highest ranking executive in some organizations may be the CEO, but in others it won't be. So it's really up to the organization and how the org chart works to determine who that's going to be. I think that's an important change because a lot of folks have built up their compliance and their cybersecurity certification around what we call sub-certifications. And I think that's going to have to be tweaked now that you're bringing in the highest ranking executive, somebody who may not be involved in this process, may not have been involved in the past, and may not have a lot of insight into how this process works. I think there's going to be a need to provide some additional sub-certifications, perhaps. Probably going to have a longer time frame for getting the chief executive officer or whoever that high-ranking executive is comfortable with the process so that they can make that certification. I think the CISO obviously will be intimately involved in the process, so they probably don't need more time to get comfortable. But the first year that you're running this, I think it's really going to be imperative that you make sure you have enough time for that. And this is a requirement that kicks in as of the next certification period. So if you're certifying, obviously in April of this year, you would have to have this process in place. So I think that's something that people are going to have to concentrate on kind of immediately. The second big change about the certification process is that now it's not an all or nothing. Now you have to certify material compliance, or you basically have to provide an acknowledgement that you're not in material compliance and what you're going to do in order to get into material compliance. So it's not that process that we had in the past where you either certified or you didn't. Now, even if you can't certify material compliance, you're still going to have to make some filing that's going to evidence basically that you are not in compliance, the reasons for not being in compliance, and what you're going to do about that. So, those are the governance requirements. I think some of them are very important, and they're going to have a big effect on companies kind of going forward. I don't know, Justin, if you have any insights or thoughts kind of on these points.
Yeah, thanks, Jeff. I will say there's a lot to chew on here, a lot of issues too, like, what exactly is sufficient oversight and sufficient understanding on the part of a board to satisfy the requirements of the regulation. That said, I will say that in the first 5 days since the regulation went final, I think the most common question that I see at companies is just understanding, okay, which highest ranking executive and which senior governing body, right? The cybersecurity regulation, this is especially in like large organizations, national or global, where there are many different subsidiaries and a parent that might be in the United States or a parent that might be in a foreign country. The cybersecurity program has always had rules that allow a covered entity to adopt the cybersecurity program of an affiliate, right? Often a parent, if you've got a parent, if you're a subsidiary and your parent has a cybersecurity program. Same with a CISO. You can use the CISO of an affiliate. Again, often the parent or a corporate shared service if the cybersecurity is being provided, across the corporate family or maybe in the North American region. So understanding like, okay, which senior governing body is that going to be, which senior, which highest ranking executive, is it going to be in the covered entity? Is it going to be in global? Is it going to be somewhere else? What does the regulation allow and what makes sense for the organization? I think that has been really one of the key questions here right out of the gate, even before we've gotten into the substance. And for some of that, it has to be addressed quite quickly. These rules are going to be effective. The certification rules are effective in 30 days, which means that your highest ranking executives will be expected to certify compliance with the regulation for calendar year 2023 in April of 2024. So these decisions are being made. There's some time pressure to make these decisions and to make them quickly. All right, moving on. So the provision that requires policies, right, different cybersecurity policies in the regulation has been amended to expand the list of policies that you're required to have. It also now has an explicit requirement that where you have policies, you also have to have documented procedures for implementing those policies. Some of these new policy requirements, they're policies that were already required in different parts of the regulation, like vulnerability management, right? And there's been a data retention requirement in the regulation since 2017, but that's just being added here to the list of policies, presumably not a heavy lift. Some of the other ones, like end of life management, that was not in the regulation as it existed before last week, but it is part of a new asset management, asset inventory requirement. So again, I think here the main issue is going to be to check to make sure to see what you have, where there are gaps. This requirement goes live in April of 2024, so you have just under 6 months to determine whether or not you've got any gaps and develop and implement any policies that you don't have today. Next, we get into sort of a range of other requirements. Some of these requirements could probably be the subject of their own webinar, but we just want to equip you with some of the key highlights here. I'll start with a big one: multi-factor authentication. Right, the original regulation had a requirement for multi-factor authentication for remote access, and beyond that, as required by your risk assessment. The amended regulation has a much broader requirement for multi-factor authentication for all user access to the information systems. The CISO can still approve exceptions in writing where can approve equivalent or better compensating controls. The main change around CISO approved compensating controls is that they have to be reviewed and reapproved at least annually. That's true pretty much across the board wherever that option exists to have the CISO approved compensating controls under the reg. It's still true here under MFA as well. Now, this is a pretty big expansion. Goes from just requiring it for remote access to requiring it from all access, remote or not. Even so, there are probably some interpretive issues that are going to come up around the margins. All users is broad, but the term user is not defined in the regulations. There may be instances where there's going to be ambiguity or interpretive work that's going to have to be done on what exactly constitutes a user and a user access. But for the most part, this requirement, it doesn't kick in until November of 2025. And for some organizations may require upgrading or replacing legacy technology that can't accommodate MFA for some types of accesses. This rule also is probably familiar to any of you that have to comply with the FTC's safeguard rules, which also require MFA for all user access that actually went into effect this year. So if you are complying with that regulation, this may be old hat. For everybody else, this is likely to be a significant new requirement. Under access controls, there's also some additional requirements. The regulation has a provision incorporating many of the principles of least access privilege. So, for instance, granting each user only the access they need to do their job, periodically reviewing all user accesses and privileges and revoking the ones that people don't need. Another one that is on this list that the department has highlighted before in other guidance is important is disabling or securing remote access protocols. Those kinds of remote access protocols are one of the top ways by which hackers actually gain access to the network. So the department has mentioned that before. It's now been incorporated in other guidance, like the ransomware guidance that was put out in 2021, and now it's been incorporated as a regulatory requirement. Passwords, the department's password requirement, which requires password policies to meet industry standards, is also qualified to the extent that passwords are used, given that passwords as a means of authentication are most experts are recommending sunsetting it. All right, more requirements into the broad category of other requirements. Asset inventory, right? This is a big one, potentially, and you are seeing this trend towards more inventory type requirements, not just in DFS's regulation, but in some other regulations. For instance, if you look at the SEC's proposed broker-dealer rules, it will say that the risk assessment has to be based on a complete asset inventory. And the DFS's implementation of this rule requires complete policies that are intended to provide for an accurate and complete asset inventory and include certain attributes like who's responsible for the asset, the sensitivity or risk classification of the asset, end of life of the asset, and recovery times objectives in the event that the asset goes down. Again, this is one of the requirements that doesn't phase in until November of 2025, but still potentially a very significant one, given that it may require some organizations to get or implement new technology in order to maintain the inventory like that. Cybersecurity training for all users must be at least annual. There was a cybersecurity awareness training in the original regulation. It's been expanded to require to include training in avoiding social engineering attacks, and that it be done at least annually for everyone, for all employees. Vulnerability management requirements have been expanded too. There's an explicit requirement for automated vulnerability scanning of the information systems. And there are also an explicit requirement that vulnerabilities be timely remediated according to risk. That requirement, there's also a penetration testing requirement, which has to be at least annual. And it does require penetration testing from both inside and outside the network. In other words, penetration testing that seeks to get into the network from outside, and penetration testing that seeks to move laterally or escalate privileges inside the network. Another potentially important point that you should make sure to at least look at is a change that was made to the encryption requirement. The department has removed the exception that used to allow CISOs to approve compensating controls for encryption in transit over external networks. So again, whether or not this is a significant issue for you is going to depend on whether or not that applies to any of your, whether or not you have such CISO approved compensating controls in place now. If you do, you are going to have to phase those out. So that's another area. That requirement's not going to kick in for a year, but that's another area where I would recommend that you evaluate it immediately and determine if you're going to have a gap when that new rule goes into effect. So, Stephen, I want to kick it over to you again and just ask you about the vulnerability management requirements and the implications of these expanded requirements for financial services companies.
Yeah, absolutely. Thanks, Justin. Again, a little bit like the incident reporting topic, this is an area where for many companies, they will find themselves entities subject to the rule will find themselves already doing what's required here in terms of both the scanning and the remediation. But some companies may find that their programs, when they assess them, aren't quite as mature as they may want them to be, and they do have to sort of level up a little bit to come into compliance with these requirements. I think as they do that, I mean, one of the challenges we often see in the vulnerability management space is around this idea of remediation based on risk, having an appropriate way to prioritize the risks that you face and the vulnerabilities and the way they have to be remediated. Obviously, every vulnerability isn't created equal. There are some that have open a very large door into a system, so to put it simply, and others that open a small door or a path to another door. But again, the risk that they may ultimately present may depend on many other factors, including the nature of the data that's held on the relevant systems and other mitigating controls. So having actually a sound mechanism for assessing risk, for scoring vulnerabilities, and prioritizing based on that scoring that works for the business is definitely something that can take a little bit of time to get right. For companies or for entities that aren't that haven't necessarily moved that far along on that journey already, this is definitely something that merits a little bit of attention because it can take a little bit of calibration to make sure you have your risk your assessment, your severity assessment, and follow-on activities appropriately calibrated. Justin?
Thanks, Stephen. All right, so with that, let's jump into a new category. The original regulation, apart from some small business exceptions, was a one-size-fits-all cybersecurity regulation. The department has created a new category for what the regulation calls Class A companies for larger companies. And that classification comes with additional cybersecurity requirements. There were a few of these that, not a number, but a few that dropped out during a few additional requirements for big companies that dropped out during the revision process. But I would expect that having created a separate category for larger companies, possible, maybe even likely, that in the future, the department will direct guidance or future requirements towards this category of Class A companies, larger companies, that in the department's estimation have different requirements, right? More substantial requirements under the regulation. So definition, what is a large company according to the regulation, Class A company? It is a company that has at least 20 million in New York revenue and either $1 billion in total revenue or 2,000 plus employees. Now, that is fairly straightforward, but the complexity comes from the fact that you do count all affiliates, not just the covered entity licensed by the department. And remember that under the regulation, affiliate is a broadly defined term that includes any entity that shares common control with the covered entity, right? So that is typically going to include, if you're a subsidiary, the parent and all of the other subsidiaries. There is an exception, which states that you don't need to count affiliates if the covered entity doesn't share information systems, cybersecurity resources, or cybersecurity programs with the DFS licensed entity. That exception probably not likely to apply to the typical financial services company that has a DFS licensed subsidiary. In part, in my experience, those kinds of companies, if you're bank, global insurance company, or even a mortgage servicer or money services businesses, can be more varied in their structures, but typically you're going to have some common technology and cybersecurity elements across the corporate family. All right, and then I'm going to turn it over now to Jeff, talk about some of the requirements that are specific to large companies.
Thanks, Justin. I guess I'll start off talking about, we've got a few up here on the screen, and I think the good news is, with the exception of the first bullet, you have until May of 2025 to kind of comply with these requirements. I think because they're highly technical, obviously, that companies will want to start working on these sooner rather than later. And when I say companies, I mean those companies that are basically just determined that they are Class A companies. And I think that's obviously the initial determination that folks have to make, is whether they fall within this category based upon the criteria. As Justin said, it's a little vexing sometimes because of the way they include affiliates, the way you have to look back at 2 years worth of revenue and things like 2 fiscal years worth of revenue. So it's a little bit like when we tried to calculate the exceptions, I guess, when the reg first came out, and you're kind of going through and doing a lot of different math and a lot of different numbers, but it's really up to the institutions. I mean, I think there were some technical, interpretive questions you can ask about what the DFS is looking for, but ultimately it's up to the institutions to try to determine whether they're in fact covered and these other requirements apply to them. I think the first one, the independent audit requirement, going through the process, the DFS was kind enough to help define what an independent audit was. They defined it in a way that allowed you to use both internal and external audits. So like for a lot of large financial institutions, you may have an internal audit group that is effectively, and is by all intents and purposes, independent. So you don't necessarily have to have a third party who's doing this. But for some entities who don't have internal audit, they may rely on third parties. This was supposed to be an annual requirement, at least in the proposal, but that has subsequently been dropped so that it's basically as determined by the institution's risk assessment. Based upon your risk assessment, you have to determine how frequently you need to conduct an internal or an independent audit of your cybersecurity program. Also, companies have to have an endpoint detection and response system. There's a need to have a privileged access management system. You also need to have the ability to block common passwords from being used. Obviously, the first question people are going to be asking there is, well, what are common passwords? Outside of the word password, probably. But obviously, I think there are some guidance around that, and I think that's something people will have to focus on as they go about putting this in place. Again, the good news is I don't think a lot of these aren't going to come into place until May of 2025, so you'll have some time to do that, but it is going to require some operational changes, and operational changes obviously take a lot more time and effort than just marking up policies and procedures. So it's something we would obviously suggest that folks get working on right away. Justin, we turn it back to you.
Thanks, Jeff. And another thing, the only thing I'd add to that really is that the regulation does not define the required scope of the independent audit, except for to say that it has to be based on the risk assessment. So for the time being, that's going to be, an individualized assessment by the company. Again, probably an area to pay close attention as to whether or not the department puts out any more guidance before this requirement goes live on exactly what has to be recovered by such an audit. All right, so next I'm going to talk about the new enforcement section in the regulation. The prior enforcement section was just a single sentence. It has since been expanded to cover a fair amount of ground. Part of that is the incorporation of explicit mitigating and aggravating factors, or just factors that the department will consider when evaluating an enforcement case, whether or not an enforcement case is appropriate, and also the disposition of an enforcement case that the department thinks is appropriate. Most of these factors closely track the factors you might see from other regulators, and they're actually set forth too in the New York banking law. The New York banking law has a similar set of factors. Until now, there was not such a set of factors the department used outside of the banking law, although the department has said in previous cases that it essentially used a similar set of factors in enforcement cases, even if the institution that they were investigating wasn't a bank. Right? It includes factors like the company's cooperation with the department and other government agencies, history of prior violations, the extent of any harm to consumers, if any, the timeliness of any disclosures by the company, willfulness of the violation, and including how high up awareness of the violation extended within the company, size of the business, and some other factors like that. One of the things that is in this list that you don't see in other similar lists, whether in the New York banking law or elsewhere, is whether or not the company's policies and procedures are consistent with a nationally recognized cybersecurity frameworks, such as the NIST framework. It's always been true that, for many reasons, companies and regulators preferred, or at least made it easier for them to see how a company's cybersecurity program was implemented and followed a cybersecurity framework like NIST. Now that is explicitly incorporated as a potential mitigating factor in an enforcement case. The other key aspect of the new enforcement section is that it contains a definition of a violation. It specifically says that a violation of the regulation can be either the material failure to comply with any section of the regulation for 24 hours, or the failure to secure or protect any individual or entity's non-public information due to non-compliance with the regulation. Right? Essentially, the loss of confidential information for an individual or company. Those are measures that the department has used in its enforcement actions to date, but they were not explicitly set forth in the regulation until now, and as the department's view. More broadly, when we're talking about enforcement, I do think that the department's enforcement priorities over the last 2 or 3 years, if we look at the publicly settled enforcement cases, line up with a number of the things that we've seen as focus areas in this amendment. The department's public enforcement actions, some of the most common charges have related to governance and governance type offenses, type charges, right? For instance, failure to have documented risk assessment, or failure to have a required have and implement a documented policy that's required in the regulation. That type of charge, I think, appears in more than 1/3 of the settlements that the department has reached in cybersecurity cases. Another recurring charge is failure to notify the department of an incident. That's a charge that appears in a number of different enforcement cases brought by the department, as well as false certification of compliance. That might be the single most common charge. I think it is the single most common charge brought in departmental enforcement actions. Outside of those types of governance and compliance requirements, the most common controls requirement that we've seen charged in an enforcement case by the department is a lack of required multi-factor authentication, right? And all of those areas are also areas where the department has expanded requirements considerably in this amendment. So I think it's reasonable to expect that those will continue to be priorities for the department, whether it's supervisory or enforcement. So finally, we want to discuss, before we get to the conclusion here, I want to discuss the implementation timeline. This is a lot here. I'm not going to go through it line by line. Suffice to say, we have this here in the materials. There's also this table, a version of this table exists in the client update that we circulated, and that is also on our website. I believe that it is linked to on the same webpage for this webinar as well. So if it is helpful for you to keep a copy of that around, we have that. This presentation will be available to you in a few days. This does set out the timeline for the implementation requirements. As I've said, in terms of what I think companies are looking at today, a lot of it is focused on the requirements that are likely to go into effect in the first year. That said, I definitely would not sleep on some of the things here at the bottom of the table, particularly since, as you probably have all experienced, if you have to do some kind of IT project in order to get tools to help you manage an asset inventory, or to implement multi-factor authentication, or vulnerability scanning for that matter, 18 to 24 months is not that much time if you have to implement a new technology. So while some of these requirements are a ways out there, my recommendation would still be not to sleep on them, and to start thinking about where your gaps are and what it's going to take to address those as soon as you can. And before we get to the conclusion, Stephen and Jeff, do you guys have anything else to add? The timeline or the enforcement issues we just discussed?
That was a great
summary.
Nothing for me. Go ahead, Jeff.
One thing I would say about the enforcement, and this goes back to a point I think we talked about during the proposal about the materiality. prior to this revisions, the DFS cyber reg really didn't talk about materiality, and now you can certify material compliance, and you can look at, violations, material failures to comply. I think the materiality concept obviously is something we see in SEC regulations and, most recently around public companies and cybersecurity events. But it does add another element that folks are going to have to consider, and not only consider it, but also I think cover in their policies and procedures, not define materiality, but make a determination with respect to certain occurrences and certain events as to whether something is in fact material. Can I still certify, have I violated the law? And I think the definition of materiality, at least the example they use, 24 hours of non-compliance, isn't very significant. I mean, that could mean that somebody unplugged something or left a back door accidentally open for a period of time. So I think you have to be very careful, as to when you look at something and whether you can still certify, in fact, you're in material compliance or whether you've had some material non-compliance. So it's an issue I think that people are going to struggle with going forward.
Yep, fair enough. Well, as we come to the end here of our hour, thought we'd do one more round of parting thoughts. We finished the overview of the regulation. So why don't we start with Stephen? Stephen, what's any parting thoughts on these new regulatory amendments?
Yeah, just to pick up some of the themes that we've been talking through it across a number of these different topics. I mean, incident response, for example, is hard. Vulnerability management is complicated, and sometimes, particularly in the incident response context, of course, these can be very sort of stressful and difficult, moments. So certainly, that's not the right time to try to work through some of these questions for the first time. So certainly, I would recommend really thinking about incorporating some of these new requirements and how you would respond to them into your tabletop exercises, as well as thinking, whether formally or informally, about doing some sort of assessment now about where you stand with respect to each of these requirements, and thinking through, which of the pieces are going to be significant lifts for your business and which ones are relatively easy, and thinking about how to prioritize on that basis, because to some extent, sort of the words on the page are the easy parts. Some of this can actually be quite hard to implement in practice, or to think through how it actually would work in the context of a real incident. And as Justin, you were saying, some of this work can actually take some time as well. So definitely, I think now is the time to start to start practicing and start scoping out what you need to change, so you can ensure compliance on the timelines that we walk through. I'll turn it back to you, Justin.
Thanks, Stephen. All right, I'm going to reserve the last word, so I'll kick it back to Jeff.
I'm just going to echo what Stephen said, because I go back and think about what we were doing in 2017 when the rule first came out. We were doing a lot of map and gapping exercises where basically we were just listing on a spreadsheet all the sections of the regulation in the left-hand column, and then going through and mapping those against your existing policies and procedures. I really think the best way to address this kind of going forward in some of these amendments is to do something very similar, to map, these new requirements against your existing policies, procedures, but also, operational safeguards, and then identify, where the shortcomings are, update your policies, obviously, to reflect that. But as Stephen was saying, then you have to go through and update some of your operational requirements. If you're a Class A company, there may be a number of different things you're going to have to do. You may need to get software solutions. You may need to have somebody come in and take a look at your system. So I think the sooner the better. And I think doing a mapping exercise is probably the best thing right out of the box to kind of, identify these shortcomings, identify where you need to improve and where your policies need to change. Justin?
All right, thanks, Jeff. First, a housekeeping point. Once again, I said this is a couple things. I said them at the beginning, but I'll just repeat them. Number one, within the next few days, we will make this recording and the PowerPoint for this presentation available to all of you through a link on our website. So that will be available. And then secondly, if you have any questions again, please put them into the Q&A. We're not going to have time to answer those today, but we're happy to connect with you or circle back on your questions. If you're putting them in the Q&A, please make sure that there's at least a name or an email address associated with them. I just glanced over there and I saw that some questions came from anonymous attendee. That's going to be tricky for us to respond to. You are also, of course, welcome to just email any of us directly. More than happy to help you through some of these questions. And then on the final point on the regulation, I guess I'd make 2 points here. One is a fairly granular one, right? Which is that the challenge in compliance challenge, the interpretive challenge has to do in part from the fact that there are a number of undefined terms here. We have materiality is something that my colleagues talked about in terms of there's not a definition for materiality in the regulation. Not even clear how you could have one definition for it that applied everywhere, given that the term material appears in quite a few different places. The amendment has added the qualifier material in a number of places throughout the regulation, and other terms like user access or even highest ranking executive are not entirely defined. So there are going to be some challenges. You may get some guidance from the department. If history is any guide, we'll get some, but probably not enough to answer all those questions. So for those of you in the trenches working on the compliance issues, that is likely to be, that's likely those types of issues I think are going to be recurring challenges. On a more macro level, higher level, the kind of governance rules that you see in DFS's cyber regulation, there are a bunch of new ones that weren't in the original 2017 regulation, but I think they both reflect and extend a trend that we've seen across regulations, do things like explicitly assign oversight responsibility to the board, right? To include certification requirements in more regulations and more specific and heightened certification requirements. You see that in some of the cyber security regulations that are out there, but frankly, you also see it beyond cyber, right? Particularly if you're thinking about how to make all this fit together. It does seem like whenever regulators have created guidance or new rules around emerging risks in the last few years, things like assignment of risk management to the board or risk oversight to the board, certification requirements, disclosures or reports are the norm now. It's like the new normal. You see that in emerging AI regulations that are coming from some regulators in draft or even in one case in final forms. You see that in guidance that's being put out by climate issues, by DFS and by other regulators. And so more of a macro point, but I think those kinds of governance requirements, they are already multiplying both within cybersecurity regulations and outside of them. So something to think about in terms of how you're going to make all those pieces fit together around certifications and board requirements and CISO or senior officer requirements. All right. It is you're exactly 1 hour in. So I want to thank everyone for joining us today. I hope that is helpful. Hope the session was helpful. And like I said, please reach out if you have any questions or any issues you'd like to discuss. We'd be happy to connect. Thank you all.